Hello, in today's show we will talk about your intentions. Are you committed for a long-term relationship or short-term relationship? Happy Valentine's Day. It sounds like a proper Valentine's Day question, but today we will be discussing your relationship with Canada. So don't go far away, let's get started.
Just a quick reminder before we start. Please note that whatever you hear in these live sessions or any content you see on social media by Sabirov's law firm is general information only and not legal advice. While we may use certain real-life scenarios or legal cases for learning purposes, it is important to remember that this does not constitute a legal opinion. For personalized legal advice, please consult with your lawyer or hire a Canadian immigration lawyer. Now, let's get back to our show.
So intent is very important, equally important in your business immigration to Canada. So today's topic is about temporary intent in business immigration. It's a very legal topic. I will try to simplify it. So bear with me because there are some slides that go into detail, but I think it will be useful for you. So first of all, let's set the stage for the legal analysis and what the law says in Canada with respect to intentions of coming to Canada and how it affects your visa and immigration applications. So let's dive into the law. Temporary stay, these are basic principles in the Immigration and Refugee Protection Act in Section 20B. It says that every foreign national who seeks to enter or remain in Canada must establish to become a permanent resident that they hold the visa or other document required under the regulation, and they will leave Canada by the end of the period authorized for their stay. So there is for temporary resident category, you need to prove that you will come to Canada and leave after the time for your stay, the authorized stay is over. In the regulations, it says that immigration officer or visa officer shall issue a temporary resident visa. The wording is shall, it's not may, okay? Shall issue a temporary resident visa to a foreign national if, following the examination, it is established that the foreign national has submitted proper application, of course, for worker, visitor, or student visas, and, according to the subsection B, will leave Canada by the end of the period authorized for their stay. So this is the legal background where the temporary intent comes from. The Federal Court of Canada also mentioned in its own decision that it is fundamental principle of Canadian immigration law that foreign nationals do not have unqualified right to enter or remain in Canada. So they should be qualified. In a way, they should be filtered, whether they are coming temporarily or permanently. We will come to dual intent, but in a nutshell, the principle works that the burden is on the foreign national who seeks temporary entry into Canada to satisfy the visa officer that he or she will leave Canada at the end of their authorized stay. So it's on you. That's why it's important to make your best case forward. This is from court's cases and the legislation in Canada. So let's see the dual intent. Dual intent occurs when a foreign national who has applied or may apply for permanent residence also applies for a temporary visit or as a student, as a tourist, or as a worker. So dual intent by itself is not illegal. You can have dual intent. Like in any relationship, you start temporarily, then you go permanent, right? So having two intents, initially for temporary residence and eventually for permanent residence, is legitimate under Canadian law. Intent to apply for permanent residence does not remove the individual's obligation to leave Canada at the end of their temporary stay, okay? The fact that you have an intention to remain in Canada permanently, ultimately, but you are applying for a temporary resident status, visitor, student, worker, that intention, the original intent, the good intention of remaining in Canada doesn't waive the obligation that you need to prove that you will stay temporarily and you will leave to your home country. The foreign national must satisfy the officer that they have the ability, that's a very important keyword, ability and willingness to leave Canada at the end of their temporary period, authorized regardless of a future decision to remain permanently in Canada. So that's why, as a point here, the focusing on the word ability. Many of our clients, they ask the question, can I sell all my property and then move to Canada to do business? No, that's not a good idea. That affects your ability to go back to your home country. And when you sold everything, you severed all your ties in your home country, and you're coming to Canada to do business, which is a temporary in nature because it's a worker visa and work permit. These are temporary authorizations. It may affect your willingness too. So you need to be really careful and strategic. So as I said, it's not a good idea to sell all your property and assets in your home country to do business in Canada. That's first risky. When you sell everything, maybe you're not getting a visa. So, and your willingness to go back after you arrive in Canada as a business owner and ability to go back is severely affected. So you need to have a good discussion with your lawyer on how to prepare your application in that respect. According to law, again, an intention by a foreign national to become permanent resident does not preclude them from becoming a temporary resident if the officer is satisfied that they will return back to their home countries. Okay? The fact that you have a permanent resident intention does not disqualify you from temporary residence. So these are the principles you need to keep in mind when it comes to dual intent. So okay, now it's very interesting to know how IRCC assesses your intentions. It's a very, I would say it's a very intimate in a way that how does IRCC know what's happening in your heart, okay? So in assessing an application for temporary residence, an officer may consider, among other factors, the following factors. The length of time that the applicant will be spending in Canada. Is it necessary to spend that long? They will assess that. Means of financial support. How will you support your living in Canada? Obligations and ties to your home country. That's a very important topic. We'll delve into that. The purpose and the context of your stay. What are you trying to do in Canada? The credibility of documents and information provided. And past compliance with requirements of the law and the regulations that are applicable for temporary residents. For example, visitors, students, and workers. Your previous history, basically, not only related to Canada, your previous history in other countries could be also relevant. As well as information available in biographic and biometric information sharing. Canada shares a lot of information with other countries. They can get that information back and see what did you do in the United States, in the UK, in Australia, New Zealand, European Union, and so on. So your previous history is also taken into account. So assessment, intention to leave at the end of your authorized stay. Remember that refusal document. If you've seen a visa refusal document, a letter informing you about the bad news, there are some tick boxes, right? So reading those tick boxes will help you analyze what you should put into your application and to satisfy the visa officer about your intentions. So in the tick box options, you can see that officer may tick that box which says, you have not satisfied me that you meet the requirements of the regulations, that you would leave Canada at the end of your temporary period. And in reaching this decision, I consider your ties to your country of residence or citizenship balanced against the factors which might motivate you to stay in Canada. So there's an analysis going on there. And also another tick box which lists the factors. Immigration officer will say, I consider the several factors, including your history of having contravened any conditions of your previous stay in Canada, your travel history, your immigration status, your family ties in Canada, and your country of residence, length of proposed stay, purpose of visit, and so on and so forth. So you need to read that. It gives you food for thought and to build your strategy on proving your intentions to the visa officer. Two important principles that I want you to highlight in light of this analysis. The program delivery instructions that are issued by IRCC, they say each applicant receives the benefit of a procedurally fair individual assessment which takes into account the entire context of the application. Not just one reason, okay? Entire context. Applicants have the right to have a fair and impartial decision maker. The courts have also indicated that it's necessary to avoid even the possibility or perception of bias. For example, of which may include prejudicial attitude towards the applicant and the background of the applicant, the country they come from, and so on. Examples of bias would include a belief that the applicant with open, closed, or prospective permanent residence application automatically have a desire to remain in Canada past the authorized stay. So even if you have previous history of applying for PR and probably not succeeding in PR application, that believing that history will make you automatically have a desire to stay in Canada permanently, this doesn't work. It's a bias that court gave as an example. As a last point, I want to highlight a case from a federal court. Visa officer handle thousands of visa applications per year, as court says. That's fair. Yeah, they probably handle hundreds of thousands. So visa officers are entitled to expect applicants to put their best foot forward and disclose all relevant information as it relates to their application. Best foot forward principle is explained as putting together applications that are convincing and that anticipate adverse inferences contained in the evidence and local conditions and address them. Okay, if there are red flags, you don't hide them, you address them. So this is a federal court's analysis about what do the visa officers have a right or a deserve to be served in terms of applications. Your best foot forward, analyzing, addressing each issue, all the history that we mentioned in the previous slide. If you have any issues there, you need to address that issue without any hesitation. Now, coming to the federal court, now we saw the law, the principles under which the dual intent is analyzed. Your intentions are scrutinized in a way that, do you have something in, what are you following what you say you're following? Now let's see some scenarios. Federal Court of Canada is very good source of analysis when it comes to dual intent or temporary intent. So on many occasions, federal court has decided on this issue, and the court covered various scenarios. Let's see the scenarios. So one of the scenarios was about purpose of travel, legitimate purpose. And first one is very interesting. Nature of temporary purpose can change, according to the court. The current statutory and regulatory scheme, as court says, does not say that a person's initial temporary purpose must remain constant and unchanged. So your temporary purpose may change, and court recognizes that. The only requirement is the existence of temporary purpose. In a case called Stanislavski case, where the officer denied the applications because applicants originally entered on a visitor visa and then applied for PR, their temporary purpose changed from a short stay to a long stay, and while awaiting a decision for their PR, this could not be interpreted as negatively by the visa officer. So the court didn't agree with the visa officer that, okay, you have a temporary resident purpose or intent, and it should remain unchanged. No, it can change. People may love Canada, fall in love with Canada, and want to stay in Canada, right? Court recognized that. Another one where purpose to earn money was okay. The court said it is now well settled that relying on an economic incentive to come to Canada cannot be the determinative factor to refuse a work permit application. And the court in another case says it's obvious that persons who apply for temporary work permit in Canada is doing so because he or she can earn more money here than at home. So it's okay to pursue earning money as your purpose of application for work permit. So these are the one scenarios. Another one, family ties. Sometimes visa officers say that, okay, your family ties in Canada are much bigger than your family ties in your home country. So they analyze your family ties. So accompanying family member situation where the officer's analysis of family ties is unreasonable when the officer considers the accompanying spouse and child and ends the analysis there. Okay. So the fact that, the court said, the fact that applicants' immediate family members wish to join them in Canada is a relevant consideration. Yes, it's relevant when assessing ties to home country, although this finding must be weighed against other evidence relevant to the applicant's motivation to return to their home country of residence at the end of their stay. So the fact that the wife and child are joining them is irrelevant, but you don't end your analysis there. Okay, you analyze the whole thing. And the court said officers must weigh family ties against other evidence too. Family ties in home country. The court said in one case from Iran, it is unreasonable for officers to refuse an applicant for lack of significant family ties outside of Canada if the applicant's family information form is filled that his mother, father, sister, and brother as family members living in Iran, with only one brother living in Canada. So you need to see what scales, and how much weight is given to that family ties. And in this case, which is obvious that there are more members in Iran than more family members in Iran than in Canada, and it's not reasonable for officer to refuse an application for lack of family ties in Iran, outside of Canada, in home country. So family ties is also important. Family ties in another context was about parents' PR application. The court said it is unreasonable for the officer to refuse temporary resident application for a dependent child solely because the applicant's parents have applied for PR in Canada. Solely because of that, you cannot deny that. So number of family members in Canada, again, while number of family members is a relevant factor, I disagree, the court said. I disagree that assessing family ties can be reduced to simple quantitative exercise, like 2 against 1 or 4 against 1. Officers' findings must be assessed in the context of the totality of the evidence and not in isolation in the context of the pull and push factors that they analyze. The evidence of the quality of family relationship is also important. Okay? So not only the numbers game, it's also the quality analysis. What kind of relationship you have with that particular member of the quality is this is another case very interesting for you to check out if you have this dilemma when it comes to family ties in your home country versus your ties in Canada. Other court case were about economic assessment, but now let's see what kind of instructions the IRCC gives to its own officers when analyzing economic ties. So IRCC instructs officers to ask the following questions. Is the person employed? If yes, what kind of salary? In what position? Has the applicant's employer approved the request to leave from home country to Canada? So there is a leave. If you are working in your home country, did your employer approve your departure to Canada for a temporary visit? Does the person have property? What is the value of the property? What financial obligations is the person leaving behind? What is the nature of value of these obligations? What are the responsibilities and obligations is the person leaving behind? How will they be discharged? Those obligations, whether monetary or personal obligations. So, is travel consistent with local customs or practices? That's a very interesting question, but everybody travels these days. Has the person traveled before? That's important. Your travel, if you want to be a tourist, have you been a tourist before? Or is it your first time sitting on an airplane? So that's analysis which is relevant. Even if the person's ties to home country seem to be strong, there may be other factors in the general economic and political environment of the country that make the long-term prospects of the person for the person and their family unstable. These factors should be considered in the assessment. So that's the instructions given by IRCC to its officers. So you read that and analyze with your lawyer and or by yourself in terms of economic ties to your home country. Other factors quickly, I don't want to read everything. It's temporary residence is another in another country can be taken into account. In this case, it was the residence in Dubai, in UAE. It can be renewed or not renewed. It can be denied. So the officer was entitled to rely on the fact that applicant's only temporary status was in the UAE. It can be, there's a risk of not being renewed, uncertainty, and so on. The court has validated visa refusal based on similar considerations. So that's another, if you have a status in another country other than your country of citizenship. Compliance with another immigration system. I told you before, as I mentioned, if you travel to the US, did you violate US laws, UK laws, Australian, and so on, they will take into account. Previous compliance with Canadian immigration system, which is self-evident. If you complied, that's good. Holding a valid entry visa. Some of our clients, they have tourist visas already. And it is unreasonable, according to the court, for the officer to imply motivation to settle in Canada where the applicant has a multiple entry visa already. So that's another case, and puts another valid point to get a tourist visa, maybe visit Canada to see the business environment, and then decide for yourself to do business or not. Other rules of assessment, rejection based on a single factor is not permissible. There should be multiple. It's not a one point of failure. Failure to address contradictory evidence renders the officer's decision unreasonable. If you didn't address an evidence that was obviously submitted to get to the refusal decision, the court said in this case that in the absence of evidence suggesting or implying a risk of not leaving Canada, and faced with the evidence indicating exactly the opposite, a justification for officer's conclusion to the contrary was required. So they had an evidence that they will leave Canada, they will not stay in Canada, but officer still refused, failing to address that evidence. The last one, there must be an objective reason to question the motivation of the applicant. In this case, officers, the court said, officers cannot rely on the very factor that would induce someone to come to Canada in the first place as the basis for keeping them out of Canada. It is for this reason that decisions of this court have consistently held that economic reasons to overstay will not, in and of themselves, support a refusal. If you have economic reasons to stay in Canada, to earn money, as we said before, to earn a living, that by itself cannot be a basis for refusal, okay? Now, conclusions. It was a lot of legal jargon, so sorry about that, but these are important issues. Just keep it handy to analyze, maybe. So we will go to tips for 2023 based on the law, based on the practice that we saw in the past year. So before I delve into the tips for 2024, let me share some tips, but before I share with you, I request that you subscribe to this channel. If you find it useful, like it, share it, and do whatever you can. Comment, leave your question and feedback. Tell us what you think, because this is how algorithmic world of YouTube works, and I really appreciate your support on that. So tips for 2024. Again, as we mentioned in many other occasions, evidence is the king. Evidence. Include substantial evidence of temporary intent when applying for a visitor visa, work permit, or study permit. Put together a strong application supported by convincing evidence. Deal with the red flags. There are red flags in almost every application. Remember that applicant must anticipate adverse inferences, adverse conclusions. contained in the evidence and local conditions, and address them. Your local conditions in your own home country, the economy, the challenges that you may be expecting in your home country, then you should address them, okay? If you have weak factors in your case, make sure to include strong evidence about other factors that are favorable to you. Officers are not allowed to refuse based on a single factor only. Focus on your strength and neutralize weak factors. Work with your immigration lawyer on your red flags. Family ties. Include a detailed family information form declaring all siblings and non-accompanying family members. Go beyond family information form and declare other family members. Maybe you have a very good relationship and certain kind of obligations to your extended family members. So remember, it's not about the quantity of family members. It's not about the quantity, but also about the quality of relationship you are leaving behind in your home country. So finally, establishment in your home country. Get creative. In addition to standard documents like bank statements, assets, and etc., include other documents that show your economic establishment in your home country. Some of our clients showed private school tuition fees for their children to establish that they have a comfortable life in their home country. So memberships in clubs, maybe paid clubs, expensive clubs, and organizations to establish a social network and obligations. Photos with their fiance, girlfriend who's staying behind. So get creative, not overly creative, but get more in depth in your family ties, because there are different cultures, different realities. So you need to express and show to visa officers that there are substantial things that are left behind when you're coming to Canada, and those will induce you to come back after authorized stay. Okay. These are the steps, these are the tips, and this is the legislation. If you need guidance in Canadian immigration, in Canadian business immigration, and you need to have a competent, caring, and professional team, honest team on your side, we want to be a part of your journey. Let us know if you need any help. Now it's time for your questions. Type them away, and let's have a quick break. We'll come back to the Q&A session right away.
To stay updated on all things related to Canadian business immigration, check us out on social media. Follow us on Instagram, TikTok, LinkedIn, Facebook, and Twitter for the latest news and updates. Subscribe to our YouTube channel and click the notification bell to stay informed about the most recent immigration news, interviews with top immigration specialists, and our weekly live shows. Visit our website at www.sabirovs.com for more information or to book a consultation with our team of experts.
Okay, it's question time. For those who are joining us for the first time, I do this kind of short or long presentation at first, and then in the second half, if you stay long enough, you can type your questions live and I will answer them as much as I can. If I cannot answer them, I will reserve them, and if you put your questions as a comment, my team and I will come back to that question and answer them at a later date. Okay, let's get the questions. I will read. The Usman Muzaffar is asking, can you please share the slide with us? Usually we don't share the slides, Usman, and this video will be on YouTube and many other platforms. If you follow us, you can always get a screenshot easily. Unfortunately, I cannot share the slides, okay? Next question. All right. Hello, Abrar is asking the question, how can Central Asian entrepreneurs benefit paying tax, growing their businesses from Canada's business visa programs? Okay, well, there are many entrepreneurs from the Central Asian region, specifically from Uzbekistan, Kazakhstan, and other countries of the region. They come to Canada through startup visa program or other entrepreneur work permit program. They become Canadian businesses and comply with Canadian laws, tax laws specifically, but at the end of the day, they benefit from the Canadian market, consumer market, plus the North American market that is open to Canadian businesses. In addition to that, Canada has around 15 free trade agreements with foreign countries, including the European Union. If you produce goods and services in Canada, you can export to those markets too. So Canada probably will serve a very good entry point to all these markets that I mentioned. And yeah, taxes, tax and death are inevitable in Canada. You need to consult with a tax lawyer when it comes to taxes. This is something that I don't know much about. Okay, Shana is asking question. Hello and thank you for this session. I sent an ICT application to Ankara in March 2023. So far, no news. Isn't that strange? How can I follow up? Web form or? First thing to follow up is the web form. Second is if you hire the lawyer, ask the lawyer to follow up with the Ankara office, embassy in Ankara, Turkey. Web form are very good and they're quite responsive, and you enter all the necessary details of your application, the UCI and the form, the numbers that associate with your application. They get back to us in our practice within 2 to 3 days. Web form is a very effective way, and of course, if you are working with a lawyer, having that lawyer to follow up, it's also a good practice that we do at Sobirov's law firm. All right, okay, no more questions today. Thank you for your active participation, and for those who are celebrating the Valentine's Day with all the love and drama, happy Valentine's Day. See you next week. Take care of yourself. Bye-bye.